Delphi case update. The records have been unsealed, or at least a redacted copy of the records have been unsealed. So on November 29, 2022, today, Judge Gull has determined that the state has failed to prove by clear and convincing evidence that the information needs to be excluded from public access. And she finds the public interest is not served by prohibiting access to the public. And she's ordered a copy of the documents she reviewed on November 22nd, 2022 to be filed and accessible to the public. So what that means is we have redacted charging information and probable cause. I'm going to go over that real quickly here. The information in the case is basically what the state thinks they can prove if they go to trial. Just as I thought, the state of Indiana has filed felony murder charges against Richard Allen. They do not think that he intended to kill the victims, but the victims died while he was committing a felony or attempting to commit a felony, particularly kidnapping, which is right there. And so that's for both victims in this particular case. Again, the state does not believe that he intended the victims to die. However, Indiana does call felony murder murder, and it's the same punishment, but he did not intend for them to die. So that is the information charged in the case. This is what the state of Indiana would have to prove to get a conviction against Richard Allen. Now, the charging information, which is this right here, we got to the charging information because the state of Indiana filed a probable cause affidavit. Now, the probable cause affidavit is available online. I just Googled probable cause affidavit in Delphi. You can see this, and this is redacted, meaning that some witness information has been taken out to make sure that people can't be harassed or anything like that. And the probable cause affidavit, very important to understand, this is just a very low standard of proof, nowhere near what's necessary to obtain a conviction, but basically enough evidence for a judge to say, yeah, a crime likely has been committed. So again, probable cause does not mean he's guilty. The probable cause does not mean he more likely than not did it. It just said, hey, a judge looks at this evidence and says, hey, it looks like a crime occurred. It's very important to understand this is not enough evidence to obtain a conviction. And if they showed this evidence to a jury, this piece of paper, they would have to, by law, result in a not guilty verdict. But this definitely is helpful to know what 6 years of investigation has brought forward. And so there's a few things in here. If you review this, the big takeaways are that, Richard Allen was near the scene where the bodies were discovered. Richard Allen owns clothing similar to Bridge Guy picture, which is blue jeans, blue jacket. A witness says they saw Bridge Guy with bloody and muddy clothing, and then they found an unspent round, meaning it was not fired, a bullet that was not fired, between the two victims. And that unspent round, they matched to a gun owned by Richard Allen. I'm trying not to smirk because I got some thoughts on that unspent round being matched. But I just want to walk through this, and I have some notes to my left here. I'm sorry this isn't as nice as my other videos, but I wanted to get something out pretty quickly for you guys. My response to he was near the scene, Richard Allen told investigators he was near the scene back in 2017. He freely interviewed with investigators, told me, yeah, I was over there. I was looking for fish. I was walking, looking at a stock ticker, but he met with them in 2017. They've known Richard Allen was near the scene since 2017. Proximity to a crime scene alone is not enough to sustain a conviction. I'll be the first to admit it doesn't look great. I wish he wasn't anywhere near there. That would help his case tremendously, but just being near the crime scene, I don't think that's very dispositive of guilt or innocence, but it definitely adds a little flavor to it. The second thing is, Richard Allen admits that he owns clothing similar to Bridge Guy, meaning he owns a blue jacket and blue jeans. Well, I would argue that, I would even mention that perhaps most of Carroll County men own blue jeans and blue jackets. I would even say most men in Indiana own blue jeans and a blue jacket. I can't speak for other states, but I suspect lots of men across the country own blue jeans and blue jacket. I don't think this adds too much at all to this case. The third thing is a witness saying that they saw Bridge Guy or someone similar to Bridge Guy with bloody and muddy clothing. Well, number one, they were driving when they saw this bloody or muddy clothing, and apparently, how fast were they going? How far away were they? Can they identify blood versus mud from a distance? How good are they at identifying blood versus mud? What have they been doing in their life? But most telling and most troubling is they got, you know, they've had 6 years to do this investigation. 6 years. And the probable cause affidavit on the 4th page says that the witness who saw the bloody and muddy clothing saw the bloody and muddy clothing on February 13th, 2022. What's the big deal, right? This occurred in 2017. This is a 6-year investigation, and this is what they're giving to the judge and to the public? I suspect that's a typo. It should read 2017. I suspect maybe it shouldn't, but I'll give them the benefit of the doubt. But they've had 6 years to get this right. This isn't a situation where the public demanded answers yesterday or last week. They've had 6 years to get this right, and they're making mistakes like this. This type of mistake, criminal defense attorneys, we love it. Absolutely love it, because we hope and we pray they made other mistakes. Now, justice for the victims, we don't want mistakes like this. But I hope the investigation is better and they put more effort into getting results for the victims than making these type of silly mistakes. This is unexcusable, in my opinion. 6 years, people. 6. Not yesterday, not last week. They're not rushing. 6 years, and they can't get this right. I don't think that this witness's statement about this bloody or muddy clothing means anything. I think it's questionable at best. I mean, how can someone... Definitely blood. I mean, that's wild. The worst thing they have on Richard Allen is this unspent shell casing found between the two victims that they say matches a gun owned by Richard Allen. Number one, they've had this case for 6 years. They knew Richard Allen was near the scenes in 2017. Why is this coming out now? And so, this is the worst piece of evidence against Richard Allen, though. I truly do believe that. Here's my question, though. How reliable is testing for unspent rounds matching to a particular gun? Now, while I was researching this and reading things, I found 2 particular cases in Indiana that dealt with matching unspent rounds, unfired bullets, to a particular gun. The first one is Simmons v. State. There's only 2 of substance. Only 2 cases that I can find talk about matching unspent rounds to a particular gun. In Simmons' case, they had 3 fired bullets, 3 fired rounds, and 1 unspent. And they said, looking at all 4 of those, they said they all came from the same gun. So, just like geometry class, 3 points make a line, 1, 2, 3. They're saying, hey, we can match all these because we have lots of them. Lots of rounds to exchange and look at. The other case is Brown v. State. Now, Brown v. State, they simply said, well, the unspent rounds in the possession of the defendant matched the similar type of rounds that were actually fired at a victim. So they weren't trying to match them to a particular gun, but they're just consistent with the weapon. That's it. Those are the only 2 cases I found in Indiana that talk about unspent rounds and matching to a particular gun. This is a redacted probable cause, but they only have 1 unspent round, and they have trying to match that round to Richard Allen's gun. I am not a ballistics person. I don't play with guns. I don't have my lifetime permit, and I exercise my rights accordingly, but I'm not a ballistics person. But I was a prosecutor before I became a defense attorney. And as a prosecutor, I did spend a day with ballistics. I was taught that in order to match a bullet with a particular firearm, the bullet needed to be fired out of the gun, and based on how it travels outside the gun, certain markings are made on the shells, and they can match fired bullets to a particular gun based on how it travels out of that gun. I'm not being the most articulate person. I know someone's going to comment, oh, Mark, that you don't know, you're talking about firearms. That's a very rudimentary understanding. Again, I'm not a ballistics person. I'm not a big gun nut or anything like that. But this matching an unspent round to a particular gun goes against how I was trained when I was a prosecutor. And that's completely foreign to me. And I was hoping when I would look up some cases, I would find some more information on that. But there's only 2 cases of note in Indiana with this unspent round. So I'm not impressed with this evidence of unspent rounds. This is the opposite of what I was taught or how I understand ballistics testing to be. This bullet, though, is the worst evidence that Richard Allen's attorneys are going to have to figure out. And I hope they got some experts in their back pocket. I hope they can find some ballistic people. I'm hoping they get some research, because this does not sound like sound science to me. And definitely not worth 6 years of investigation. But after reading this PC, I totally get why the prosecutor would like to have it sealed and not available to public, because it sounds pretty weak when I'm reading it. So, again, 6 years of investigation is pretty weak, in my opinion. The other surprise that I found, which wasn't really surprising as well, yesterday, the attorneys for Richard Allen filed for a change of venue. They want out of Carroll County. They did a really good job in the memo they filed with the judge, the motion. But basically, they've shown through Google research, by keyword research, by, information that Google actually will do, they estimate 1 out of 2 people in Carroll County, only about 3,000 people live in that county, but 1 out of 2 have Googled Richard Allen's name, meaning they're going to have a hard time finding jurors that aren't familiar with the case. And their suggestion is to move it to a bigger county with more people who might not have been familiar with Richard Allen. They mention, I believe, Allen County, where Judge Gull is from, where only 1 in 26 people is estimated to have Googled Richard Allen. So they're hoping to have a better shot of finding a unbiased and impartial jury, which, that's the goal in these criminal type trials. So that's my quick update. Sorry, the production value in this video isn't great. Again, not impressed with the evidence I've seen. I totally get why the prosecutor would like to have had that sealed. It's very, very important. Richard Allen is innocent until and unless proven guilty in a court of law. It's also important that you always plead the fifth. You just always plead the fifth. You can't go wrong pleading the fifth. If you agree with me, awesome. Make a comment. If you disagree with me, even more awesome. Make a comment. Most importantly, though, subscribe. Look forward to reading you guys' comments, and I'll try to respond to all of them, but I cannot promise you I will do that.